Joining me from Abuja is the chairman of the House Committee on Corruption and EFCC, Kayode Oladele. Good morning to you, and thanks for joining us on the show this morning. Now, let me get first of all your reaction, or how would you respond to President Buhari's seeming cry that the judiciary is his main headache?
Well, President Buhari has just lent support to a voice to what we've been saying all along. Before now, it's been the contention of some of us that the laws of the land, particularly the Criminal Justice Administration, is being hampered by archaic and obsolete laws that prevent effective administration of justice. So therefore, it's saying exactly what we've been saying all along. And we welcome that development, that we need to review some of our laws.
Well, there are those who say actually that, the president may be wrong when he says the judiciary is his main headache and not the legislature. You've said it yourself. You've actually seen, or you confirm that there is a need to tinker with the laws in terms of the punitive measures that are, meted out on corrupt public officials. So what exactly are some of these amendments that you're working on, if at all? Which areas do you think we really need to work on seriously?
Let me tell you, one very important area is the Criminal Justice Administration itself. Hitherto, a person could prolong a trial for as long as 10 years, going through interlocutory appeals. Just a small interlocutory decision or order of the court can be appealed up to the Supreme Court level. And that can prolong unduly anti-corruption cases. So just before the last assembly wound up, they passed the Criminal Justice Administration Act. And the whole essence of that was to ensure that a speedy trial of anti-corruption as well as anti-terrorism cases. The meaning of this, therefore, is that no longer interlocutory appeals. That if there is any interlocutory decision, it can be reserved for appeal until the final decision is taken on the case. But before this time, that was what we used to have this, they call it practice direction. And the whole essence of practice direction was to also make sure that there was speedy trial. Judges were enjoined not to grant interlocutory appeals, particularly the Court of Appeal as well as the Supreme Court. But see, the practice directions were not being implemented by the courts. In fact, a lot of lawyers were not aware of it. I remember when, about 2 years ago, when I mentioned it in one of my interviews, some lawyers called me and asked me, are you sure we have practice direction in Nigeria? And I said, yes. We have practice direction for the Federal High Court. We have practice direction for the Court of Appeal, as well as the Supreme Court. But the fact of the matter is they were not being implemented. But with the enactment of Criminal Justice Administration Act, that put paid to the issue of the practice directions. Therefore, it is now left for the courts to implement the new law.
Okay, just educate us a little on this practice direction that you're talking about. It must be a legal jargon, and I'm wondering what exactly it is. Do you want to, what exactly is this practice direction? Yes.
Yes, practice directions are instructions given by the Supreme Court, particularly by the Chief Justice of Nigeria, to all the courts. But the Federal High Court has its own practice direction. That is instructions on how to handle some cases. For instance, part of the practice direction, in the instruction was that anti-corruption cases as well as anti-terrorism cases should be given expedited trial, and that they should, if there was going to be any adjournment, such adjournments should be very, very short, not a long adjournment. Part of it also was that judges were instructed not to grant, particularly the Court of Appeal, not to grant interlocutory appeals and stay, particularly stay. You know, when lawyers file an appeal itself does not operate as a stay. Therefore, they have to come back to the court and ask for a stay. So what the party's direction says is that judges should not grant a stay when the matter to be appealed upon concerns terrorism or anti-corruption cases.
Okay, so in other words...
But as I said, you know, they were being ignored.
So in other words then, would one be right to say that the real problem may not necessarily be the judiciary, but the instruments of law that the judiciary actually uses, you know, to apply the law where it is required? I mean, the judiciary has actually, you know, hit back saying that, look, this really is not a problem of the judiciary. Our job only is just to interpret the laws. You know, putting it back the doorstep of the legislature, you know, to which you belong.
Well, I want to disagree with what, with due respect, I want to disagree what the judges are saying, because, you know, fighting corruption is a collective responsibility of every one of us. So if judges are in charge of interpreting the law and making sure that they hear these cases, it is their responsibility to ensure that these laws are well implemented. As I said, we have parties' directions. It is not the duty of the EFCC, for instance, to implement what the party direction says. It is for the judge to say that this is the party's direction. As I said, many lawyers are not even aware. So the judge has the direction in his hand. He knows what the law says, but in most cases, they just discountenance. And again, there is a lot of patronage. So that's a different thing, because we can't also raise the fact that there is a little bit of corruption too in the judiciary. So it's a combination of all.
When you say a little bit of corruption in the judiciary, are you trying to play it down? Is it just a little bit, or is it really bad that we have the situation, you know, where politicians, how many really have been punished in this country? Since we've been crying corruption till we're hoarse, and no politician really has been punished, except those that are punished by other, you know, legal systems in other countries. A job that we should have done here. Taking the Ibori case, for example, or, you know, as many cases as one might cite.
This is the same thing I'm saying. You know, we are talking of corruption. When I say a little corruption, I don't want to condemn everybody. I don't want to give a blanket condemnation to say that all judges in Nigeria are corrupt. That is not true. We have some fine judges. We have some judges that are very, very strict, and they interpret the law the way it should be. So I don't want to give a blanket condemnation, but of course we have some bad eggs, because judges do not fall from heaven. They are taken from the society. We have some of them who are also very, very corrupt. Okay, when you are talking of the Ibori case, don't forget the judge that first had the Ibori case in Delta acquitted him. And then, of course, we before the matter was moved to Kaduna, and of course, eventually Ibori left. We know very well that some judges are compromised, that not all judges are compromised. But I also know that they hide under the criminal justice system, the weakness of the institutional system itself to do whatever thing they want to do. Okay, you are talking of judges or some of the politicians not being convicted. How can you convict somebody, for instance, whose case was filed about 10 years ago, who is still pursuing an interlocutory appeal on the issue of jurisdiction alone? And of course, without first dealing with the jurisdiction, you cannot go ahead with the trial. So it's possible that the judge will tell you that, well, my hands are tied. This is what the law says. This is what the rule says. An accused person has the right to file an appeal when there's a decision, an interlocutory order. So I cannot just do it and say I'm going ahead with the trial. So they try, what these people do, particularly the public officials and those who have money, what they do is to use the inherent weakness in the public, in the judicial system itself, the criminal justice system, to their advantage. So the new law, talking about the Criminal Justice Administration Act, what it does, it will say this can no longer happen. And the new Criminal Justice Administration Act gives time within which certain cases should be heard. So speedy trial is what we are talking about now. So once there is no interlocutory appeal, I can assure you that there will be speedy trial. Particularly on criminal cases and cases bordering on corruption and terrorism.
Indeed. Odinkalo, the human rights Justice Watch, I forget the name of that group now, but the gentleman himself has said,
yes,
look, the anti-corruption war cannot be fought effectively if the judiciary is not, reformed. What kind of reforms are we really talking about?
Yes.
If this judiciary, as it is to be, unraveled and put together?
Okay, we are talking about the lack of efficacy in the criminal justice administration system. Now, a lot of people are saying the EFCC, they are not doing their job very well, there are no convictions. They forget the fact that it is not the EFCC that will convict. It is the duty of the EFCC to do the investigation. And once there is a prima facie case against somebody, they charge that person to court, to the appropriate judicial tribunal. It is for the court to listen to the case, hear the case, and then give a decision, either a conviction or an acquittal. But when they get to court, the public officers don't care about whatever thing that happens at the FCC level, because they know that in the final analysis, the buck stops at the judiciary. And once they get to the judiciary, they know how to use the weakness in the criminal justice system to prolong the case unduly. And of course, when they prolong the case unduly, a lot of things are bound to happen. The first thing is, one, you cannot convict if you don't prove your case beyond reasonable doubt. And you can only do this with the help of witnesses and documents. So when a case is prolonged for about 10 years, for instance, likelihood are that you lose some of the witnesses, some of the evidence might be lost in the process. And of course, by the time they get to the trial stage, the prosecutor does not have much to prove the case. So unless we are able to take effective measure to take care of the absolute laws that assist the weakness of the system itself, then those anti-system players will be there for the judges and the lawyers to manipulate. Secondly, is the fact that we have judicial corruption. And when you are talking of reforming the judiciary, of course you have to go into the issue of judicial corruption. Let me tell you, judicial corruption happens everywhere. It's happened even in the US in the past. I remember there was this Operation Grey Lot they did in Chicago about 1984, when a certain judge was discovered to be taking bribes, and the FBI had to bug his lines and they had to bust him. So definitely the system discovered that there was a bad egg, and in order to ensure the integrity of that system, what they did was to take out that judge. So unless we are able to have the will to be able to confront the judiciary and say, look, we have people there too that are bad eggs, we have people there too that are compromising, and we cannot win this fight against corruption if we have corrupt judiciary. Because as I said earlier on, it is not the EFCC that will convict. It is the duty of the court to convict. And when the courts are not doing their jobs very well, when the courts are compromised, definitely the fight against corruption will be effectively compromised, and there's nothing we can do. No amount of legislation, no amount of executive intervention can fight the corruption, anti-corruption war effectively without the support of the judiciary. Because as you rightly said now, how many people have been convicted? Except those that ran abroad and they were able to be arrested and tried in another jurisdiction that are serving jail terms.
Indeed.
So once they come into our system, they don't care.
And speaking of the judiciary and corruption, we seem to just narrow it down to the judiciary and corruption in public office. What about, the justice system, the justice that is given to the ordinary Nigerian? After all, we hear that the judiciary is the last hope of the common man. Let me even take it away from the public arena for a second. Last year, I actually spoke with a warder at the Kirikiri prisons, and he told me something that is really baffling, and I'm still thinking about it till today, that 80% of inmates at the Kirikiri prison, for example, are actually innocent. Now, something is wrong somewhere.
Yes, definitely. Definitely, something is wrong somewhere. Last about 2 weeks ago, my committee on justice, not the financial crimes, Commission on Justice met with the Attorney General of the Federation, the new Attorney General. And we tried to review the past year as well as the previous years. Part of it was the prison decongestion exercise. A lot of people are languishing in jail, not because they have committed very serious crimes, but because either because they don't have access to justice, they don't have money to hire lawyers, many of them don't know their rights, and the organization, the agency set up by the government, Legal Aid Council, does not have sufficient funding to take care of this. And we also spoke with the director of the Legal Aid Council, and we asked her some of the problems that she was facing there, and she told us everything. I mean, this woman, for instance, is willing to work. She wants to do the work, but she doesn't have enough resources. She has very few lawyers to work with. And of course, don't also forget the fact that not many lawyers can work with her because she cannot afford to pay them fat salaries. So she's coping with what she has. And day in, day out, people are being put in detention, awaiting trial. So if you look at Nigerian prisons, people that are awaiting trial are more than people that have been convicted. So it is lack of access to justice. They cannot afford lawyers. And of course, the police too, their hands are full. And most of the cases are being prosecuted by the police. But there is a but there. The new law that has been enacted, the Criminal Justice Administration Act, now forbids the police from prosecuting some of these cases. And from our discussion with the Attorney General last week, he told my committee on justice that the police handed to the Ministry of Justice, about 8,000 case files and 800 anti-corruption and terrorism cases. So some of these people are languishing in jail. Some of them are there, awaiting trial. And then, of course, there is also this thing they call holding charge, which is not known to Nigerian law. But the police use that to put a lot of people in detention. When certain capital offenses are being committed, instead of them to charge them before the appropriate judicial tribunal, they charge them before the magistrate courts that don't have jurisdiction, that cannot grant them bail. So because the magistrate courts don't have jurisdiction to grant them bail, every time the case comes up in court, they don't have lawyer, the case files are not ready, the police is still investigating, the IPO is still investigating, they are expecting reports from the Ministry of Justice. They keep them in detention. And many of them are. Some are there, even ordinarily, some of the cases that even if they are convicted, they probably spend maybe about 2 or 3 years in jail. Many of them will be there for 10 years, beyond the period the law even prescribes for the offenses committed. So it is right. Yes, exactly. So it is right to say that in Nigeria today, we have a lot of people serving jail terms, even though they are in detention, they have not been convicted, nothing has been proved against them. And we asked the Attorney General of the Federation, why do we have this? Under the watchful eyes of, under the tenure of former AGF Anduaka, as well as Adoke, there was this project they called prison decongestion. And they said the prison decongestion witnessed a lot of abuses, that even lawyers abused that exercise. They would not fight for the accused persons to take them out of jail, but they will go and present fake orders of court to the Attorney General's office, stating that those people are out of detention, and then the Attorney General will go ahead to pay them money. So a lot of irregularities. So when you are looking at this, we also have to blame the Nigerian Bar Association, because the association, I understand, also supervised this prison decongestion. And up to today, many lawyers abused the process. They did not take the people out of jail, and they collected money.
Really unfortunate situation there. But let's come back to the issue at hand. The NJC, the Judicial Commission, seems to have been emasculated somewhat. What role really are they playing, to see that the judiciary is totally above board like Caesar's wife?
Well, I can tell you something. Maybe before, the NJC was not doing the right thing, or the needful when it comes to sanitizing the judiciary. But I will tell you, in the past 2 years, they've really stepped up, and they've done a great deal. Some judges have been relieved of their appointments. One even had to quickly resign to take up a position of an emir for a town in the northern part of Nigeria, because he knew that it was being investigated, and that investigation could eventually lead to his removal as a high court judge. So he had to resign. So, and right now, some of them are still being investigated and being called upon to testify and defend themselves before the NJC. This started during the reign of the former Chief Justice Mukhtar. She tried a lot, and the current CJN is also trying his best. Don't also forget that about 2 years ago, the EFCC had to go into the private lives of some of these judges, and found so many very damning revelations about the amounts some of them had in their bank accounts, running into several billions. So some of them have been queried by the NJC, and those that are found wanting have been relieved of their appointments.
And that seems to be where it ends. They are relieved of their appointments, and that's it. They're not really punished. Yes. The full weight of the law itself is not carried out on this offending judges.
Well, again, you have to ask the NJC, because ordinarily when that happens, what they ought to have done was to have referred the case back to the EFCC for further prosecution, because the EFCC did the right thing. After getting the reports on these judges, they sent the reports to the NJC for action, and the NJC had to sit on the cases. And then, of course, many of them also had petitions from some litigants who petitioned against them, some of them asking for bribes for them to compromise the cases. But one would expect that after being relieved of their appointments, the case files will be either sent to the EFCC or to the Attorney General of the Federation for further action. But of course, we're talking under a dispensation that lacked certain political will to do a few things. I can imagine if that should happen today, I'm sure we will have a different report.
Now, talking about the EFCC, you've mentioned the EFCC a number of times, and I recall that there was a time in this country when the police, the civil service, and the judiciary were the main planks of public accountability and integrity. And now we have EFCC, so many, anti-corruption bodies that many, still criticize and say, look, this multiple agencies really have not made much difference in the anti-corruption drive of the different governments that we've had. especially with this present government. Is this really counterproductive at the end of the day? Are we just spreading ourselves too thin with all the anti-corruption agencies?
Not at all. Before 2003, when the EFCC was created, there was so much impunity in the country, and it affected our rating internationally. But when the then President Olusegun Obasanjo set up the EFCC and then put the former chairman at the time, Ribadu, as the helm of affairs, there was so much activity. A lot of things happened. Many people were arrested, and many were charged to court. And of course, there were some convictions too. But you see, sometimes when you are looking or you are assessing the efficacy of some of these agencies, you are only looking at the politically exposed persons. You are not looking at other areas that these agencies are working on. We have the cyber crime, we have the advanced free fraud, and other crimes, or financial crimes, that continue to affect the image of the country outside every day. And today, with the help of these anti-crime or anti-graft agencies, we've been able to nip some of them in the bud. Of course, we still have a pockets of them here and there. But because we are always looking at the politically exposed persons, we are not looking at the other areas. Then it's very easy for us to say that, well, they are not doing their work, And if you look at our discussion this morning, we look at the efficacy of the EFCC vis-a-vis the support they get from the judiciary. Because once they finish their files with their investigation, they push it to their lawyers to go and prosecute. So they are doing their best, they are working hard, and of course, today I can tell you that the fear of EFCC is the beginning of wisdom. One way or the other, they are trying to caution impunity in the country, because corruption is not only the bane of our society, impunity is part of it. And today, they are not saying you should not find yourself in it, but one thing is that you will have nowhere to run to.
All right, Mr. Oladele, Honorable Kayode Oladele, Chairman, House Committee on Corruption and EFCC. Just hold on a bit. Let's go to Port Harcourt, Rivers State, to find out what the people think about the role of the judiciary in the war on corruption.
Judiciary is no longer as strong as it was before. Usually these days you can actually buy your way into the judiciary. The judiciary are no longer giving just and fair decisions or judgments in cases right now.
We know fully well that since the court has the final say in every situation, then in that sense you can't say they are corrupt, except the government, in quotes, lure them to do those things that they ought not to do, or has contravened from the Constitution, or has indeed went as far as ultravening those rights and privileges given to them. You cannot impute that indeed they are corrupt.
Nigeria is on a progressive era where the three arms of government, talking about the executive, the judiciary, and the legislature, that means now the judiciary are doing their job. And remember that judiciary is the last hope of the common man.
Judiciary, the judges are no longer independent as they are supposed to be. In the judiciary, in cases that are going on, people can just pay their way through to get a particular judgment. The president can say something in a case and it will stand.
I do not think that the judiciary has done what it's supposed to do in order to tackle corruption in this nation, because we've seen that most men in the hierarchy, in the social class, you understand, over the years have gone against the laws of this nation with impunity. They've invested our money. Just imagine James Ibori, why he was tried in Nigeria, you understand? They discharged and acquitted him, but he himself pleaded guilty. I don't know if you get me. So to a large extent, the judiciary has not done what they're supposed to do to tackle the issue of corruption in this nation.
Honorable Oladele, it doesn't seem that many Nigerians there, especially in Port Harcourt, have confidence in this judiciary. There are those too who've criticized this president maybe even shooting himself in the foot by saying that the judiciary is his main headache when he himself is, perceived to be flouting the, judgments from the court, especially when it pertains to bail and, whether or not bail should be carried out, looking at the Dasuki and the Nnamdi Kanu case.
Well, a lot of people, when you fight corruption, corruption also fights back. A lot of people don't understand what is going on. A person can be charged with a particular offense and taken to court. And when he gets to court, the court grants him bail on that same offense. But while that matter is going on, there's an investigation, and there's an ongoing investigation. And that same person has been found culpable of committing a separate offense, a new crime, entirely different from the one he's been granted bail. So even if he's granted bail on let's say, count A, that's the subject of the court bail. As soon as he comes out of the court, he can be rearrested based on a fresh charge. It has nothing, absolutely nothing to do with the one the court just granted him bail. But because corruption is fighting back, because of propaganda, people will say that this was a man that has just been granted bail by the court, and as soon as he comes out of the court, he's picked up again. It shows that the government is not obeying the court order, not knowing that what that person has been arrested for is a fresh charge that has nothing to do with the one the court has just granted him bail. And this is exactly what we are saying. I was reading something yesterday. They said Ibori in UK, Ibori released and rearrested. If that had happened in Nigeria, they would have said that why was he released and then he was rearrested immediately. One can be serving a jail term. As soon as he comes out, there's a fresh charge waiting. One can be taken before an administrative tribunal or a court of law, and it's being granted bail by the judge. And as soon as he's coming out, there's another fresh charge waiting for him. He can be rearrested. It's not a one bail or one order catches all. It doesn't happen like that. Once all the counts are not on the same charge sheet, on the same information sheet, he can be arrested again. And it doesn't mean that the government is faulting. So all these things are just mere propaganda to discredit the president.
Last note, what would be your take on the way forward for the judiciary, so that looking at the executive, the legislature, and of course the judiciary, the three arms of government, that we don't have a judiciary that seems to be the weakest link in this chain?
Well, for now, the judiciary appears to be the weakest link. I granted an interview about 2 months ago, and I said without effective judiciary, we cannot win the war against judiciary, against corruption. And this is because for everything that we do, just like Riley said, judiciary is the last hope of common man, and it's the last hope of everybody. Don't forget that an accused person is deemed innocent until it's proved beyond reasonable doubt before the court of law. And no matter the work of EFCC, no matter the work of ICPC, no matter the legislation, no matter what we do, the buck stops at the desk of the judiciary. It is for the judiciary to put effect to everything. So if the judiciary does not support the legislation and the executive, as well as the people in the fight against corruption, there's no way we're going to win it. So what I would say is this. It's not as if one is putting everything at the doorstep of the judiciary. But what I'm saying is the fight against corruption is a collective responsibility of everybody. The executive, the legislature, the judiciary, as well as the general public. No one can do it alone. So it's just that today we are looking at as you rightly put it, the weakest link. And the weakest link when it comes to that right now is the judiciary. All the laws are there. For us at the National Assembly, we are reviewing all the laws. In one day, we introduced 138 amendments. And this is to ensure that we put all our laws up to date. We make sure that they are in tandem with the current standard, so that the judiciary can have something to work with. But having done that, it behooves on the judiciary to ensure that the right thing is done.
And on that note, I want to say thank you very much, Honorable Kayode Oladile, Chairman, House Committee on Corruption and EFCC, talking to us about the role of the judiciary in the anti-corruption drive of this government. Thank you very much for your time. We'll take a short break, and when we return, TVC Breakfast continues.